India Legal presents Court This Week.
Hello and welcome to Courts This Week. I am Tanya Chug. In this special edition, we bring you top stories of legal proceedings from the courts, from lower and subordinate courts to high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
A special CBI court at Thiruvananthapuram sentenced Father Thomas M. Couture and Sister Sefi to life imprisonment for the murder of Sister Abhya 28 years ago. Both convicts are required to pay a fine of 5 lakh rupees each. Both convicts were charged with murder and destruction of evidence, among other things.
A Central Bureau of Investigation court has sentenced Father Thomas Couture and Sister Sefi to life imprisonment for the 1992 murder of Sister Abhaya at a convent in Kottayam district of Kerala. The two have also been required to pay a fine of rupees 5 lakh each. Apart from the 5 lakh rupees fine imposed on the two, Father Couture has been directed to pay a sum of rupees 1 lakh for house trespass. Earlier, CBI Judge K. Sanil Kumar pronounced Father Thomas Couture and Sister Sefi guilty in the 28-year-old murder investigation. The two, along with another, had also been charged with murder and destruction of evidence and house trespass, that is, Section 302, 201 and 449 of the Indian Penal Code. The second accused, Father Jus Putrukail, was discharged from the case in 2018 for lack of evidence. The prosecution had pleaded for maximum sentence of death penalty for the culprits by arguing that case belonged to the rarest of the rarest category. The defense lawyer pleaded for leniency in sentence. It was submitted that Couture, 71-year-old, was suffering from cancer and Sefi has aged parents to take care of. The verdict came more than 28 years after Sister Abhaya was found murdered at a convent in Kottayam district of Kerala. Her body was found inside the well of the convent on 27 March 1992. The case itself saw many twists and turns before it was eventually tried in court. In 1993, the state police filed a closure report saying it was a case of suicide. The matter was then handed over to CBI after an activist, Jamon Puthenpurakal, took it to the court. However, the CBI in 1996 filed a report stating it could not conclude whether it was a homicide or suicide. The court, however, rejected the same and ordered reinvestigation. A year later, CBI concluded that the case was indeed a homicide, but there was no evidence to try to the case. This was again rejected by the court and a third round of CBI probe began. 10 years later, the first arrests are made in the case when Father Thomas Couture, Father Jus Putrukail and Sister Sefi were arrested and charged for the murder in 2008. They were later granted bail by the Kerala High Court in 2009. Putrukail was later discharged. Pursuant to a High Court order this year, the trial resumed and verdict were pronounced. A single bench of Justice V.G. Arun noted that the long delay in the completion of trials and directed that the matter be heard on a day-to-day basis, lest the wheel of justice come to a grinding halt. Bureau Report.
In a setback to future retail, the Delhi High Court has refused to restrain Amazon from interfering in the Kishore Biani-owned company's deal with Reliance Retail by writing to statutory authorities.
Delhi High Court has dismissed a plea from Future Group that sought to restrain US partner Amazon.com Inc. from interfering in its $3.4 billion asset sale to Reliance Industries. The order was pronounced by a single-judge bench of Justice Mukta Gupta in the suit by Future Retail Limited after an emergency arbitrator of the Singapore International Arbitration Centre restrained Future Group from taking any steps in furtherance of the transaction with Reliance Retail. The court held that the statutory authorities were free to form their own opinion as per law. Future sold its retail assets in August to Reliance Industries in a deal Amazon said breached arguments Future made with the US e-commerce leader in 2019. In findings for Future Retail and Amazon, the court prima facie found that the suit filed by Future Retail was maintainable. The emergency award was valid and that Future Retail's resolution approving the transaction with Reliance was also valid. The court also stated that the prima facie, the conflation of the three agreements, that is, Future Retail Shareholding Agreement, Future Coupons Private Limited (SHA) and FCPL Share Subscription Agreement, granted disappropriationate rights to Amazon, which required government approvals under FEMA FDI rules. In October, Amazon had won an injunction to halt the sale from a Singapore arbitrator that the sites had agreed to use in case of dispute. Future later said the order was not binding, prompting Amazon to lodge a complaint with market regulator Securities and Exchange Board of India. The Competition Commission of India last month approved Future's sales of its retail, wholesale, logistics and warehousing businesses to billionaire Mukesh Ambani's Reliance. Future Retail Limited had announced its deal with Mukesh Ambani-owned Reliance Retail Ventures Limited earlier this year. Bureau Report.
The High Court of Jharkhand has held that the Speaker of the House is required to take a decision on question of disqualification when it is referred to him. The court observed that under constitutional mandate, no power has been conferred upon the Speaker to take suo motu decision for answering the question about disqualification under the 10th schedule of the Constitution of India.
In the case relating to powers of Speaker, the Jharkhand High Court has given an important observation. It has said that Speaker of the House can't take suo motu cognizance of disqualification issue. In the present case, the petitioner was Kendriya Adhyaksh of Jharkhand Vikas Morcha Prajatantrik, which is recognized and registered state-level political party. Its Central Working Committee conducted a meeting on February 11, 2020 and resolved to merge the Jharkhand Vikas Morcha Prajatantrik political party with Bharatiya Janata Party, a national political party. The president of Jharkhand Vikas Morcha Prajatantrik wrote a letter to the Election Commission of India enclosing the party's decision and made a request to merge its party and the legislature party with BJP. The Election Commission of India on March 6 had informed regarding merger of JVMP with BJP. When the decision of the merger was brought to the notice of Speaker Jharkhand Legislative Assembly, the Speaker issued a notice stating that he has come to believe that there is an issue affecting the 10th schedule of the Constitution. The petition was filed before the High Court after the petitioner was directed to produce evidence himself or through advocate on September 17, 2020. According to the petitioner, the Speaker of Jharkhand Legislative Assembly has no power to take suo motu cognizance to treat a case under the 10th schedule of the Constitution. As per the constitutional mandate, the Speaker has only been conferred with the power to take decision on question as to the disqualification ground of defection, if any, to that effect is referred. The court observed the Speaker is required to exercise the power for taking decision if question about disqualification is referred for such decision before him. Therefore, under the constitutional mandate, no power has been conferred upon the Speaker to take suo motu decision for answering the question about disqualification under the 10th schedule of the Constitution of India. The court held that in present case, the petitioner has been able to make out prima facie case, and if the interim order would not be granted, the same will lead to irreparable loss, and further balance of convenience also lies in favor of petitioner. Therefore, is of the view that it's a fit case where the interim relief is required to be granted in favor of the writ petitioner. Bureau Report.
In a case of grave misconduct by a judge, the Uttarakhand High Court has suspended District Judge Prashant Joshi for using forgery-accused car for official travel. On disciplinary action, the court said that this conduct touch upon his integrity amounts to grave misconduct. Said conduct is unbecoming of a judicial officer. During the suspension period, the judge will be paid half his salary.
The Uttarakhand High Court has suspended a district judge who travelled to a camp court in private car belonging to an accused after fixing the official board of district judge on that car. The High Court's office memorandum described the act of District Judge Prashant Joshi as amounting to grave misconduct and as touching upon his integrity. The act and conduct touches upon integrity, amounts to grave misconduct and is in violation of Rule 31, 32 and Rule 30 of the Uttarakhand Government Servant Conduct Rules 2002. Said conduct is unbecoming of a judicial officer. Office memorandum suspending the judge stated. The officer was supposed to have travelled to the camp court in his official vehicle. Instead, he used a private car owned by one Keval Krishan Soin, which was fitted with the judge's official name board, the memorandum said. The order pointed out that this might have been to protect the owner and the occupants of the car from nefarious activities. It also stated the vehicle was parked outside the official High Court guest house. To make matters worse, the memorandum noted that San has a case of forgery, cheating and criminal conspiracy pending against him, and a writ petition to quash the same is also pending before the Uttarakhand High Court, stating that the above actions constituted grave misconduct and violated Uttarakhand Government Servants Conduct Rules 2002. The court suspended the judicial officer and directed that he be paid only half his salary as subsistence allowance along with dearness allowance. This amount is to be paid over to him on the date of suspension. Other compensatory allowance shall be admissible subject to the condition that expenses being actually incurred by him, the communication said. It also said that Joshi should remain attached with the district judgeship headquarters through the Prayag and should not leave the station without obtaining the prior permission of the High Court. Bureau Report.
The Karnataka High Court has refused to quash a criminal complaint registered under the Prevention of Corruption Act against Chief Minister B.S. Yediyurappa, who is alleged of denotifying parcels of land and allotting it to entrepreneurs during his tenure as the Deputy Chief Minister of the state between February 2006 and October 2007.
The Karnataka High Court has refused to quash a criminal complaint registered against Chief Minister B.S. Yediyurappa under the Prevention of Corruption Act 1988. It is alleged that Yediyurappa had denotified parcel of land and allotted it to the entrepreneurs during his tenure as the Deputy CM of the state between February 2006 and October 2007. Justice John Michael refused to quash the first information report dated 21st December 2005 registered by the Kerala Lokayukt Police for the offences punishable under Section 13(1)(d) read with Section 13(2) of Prevention of Corruption Act 1988 on the basis of a private complaint filed by one Vasudeva Reddy. Senior advocate C.V. Nagesh, appearing for Yediyurappa, had contended that in respect of the very same FIR, accused number 1, Raghunath Vishwanath Deshpande, had preferred a writ petition before the court which had quashed the FIR. Therefore, in view of that order, an investigation against the petitioner based on the very same FIR is illegal and amount to abuse of process of court, he argued. The court also placed reliance on the judgment passed in the case of H.D. Kumaraswamy vs. State of Karnataka. Before parting with the judgment, the bench pulled up the Lokayukt Police for delay in investigation against Yediyurappa. The court remarked that as the investigation is still in process, it does not intend to pass any direction mandating any action against the Lokayukt Police, who is entrusted with the investigation in the matter. However, it reprimanded the police for its laxity in conducting the investigation. Bureau Report.
Kerala government has moved Supreme Court against High Court decision to raise the number of daily permissible pilgrims as 5,000. The Kerala government wants the number restricted to 2,000 per day and 3,000 on weekends due to COVID-19. In its appeal in the top court, the Kerala government has said its high-level panel had capped number of visitors to Sabrimala temple based on a health ministry advisory.
The Kerala government has filed a special leave petition in the Supreme Court challenging the direction of the High Court of Kerala to raise the number of daily permissible pilgrims as 5,000. Taking note of the COVID-19 pandemic situation, a high-level committee under the chairmanship of the Kerala Chief Minister had decided on 5th October to permit pilgrimage at Sabrimala during the present Mandalakalam season, allowing 1,000 daily pilgrims on weekdays and 2,000 daily pilgrims on weekend and 5,000 daily pilgrims on special puja days. The pilgrims were required to register through the virtual queue system and to provide COVID-negative certificate from an authorized lab. Challenging these restrictions, several devotees had filed writ petitions in the High Court. On 18 December, a division bench of Justices C.T. Ravi Kumar and K. Haripal disposed of the petition, raising the permissible number as 5,000. In the SLP challenging this direction, the state government says that the number of police officials, health officials and pilgrims affected by COVID-19 in Sabrimala temple so far is on the higher side. The entry to the temple is controlled by a virtual queue managed by the police personnel, and pilgrims are tested for COVID-19 before allowing them to enter the temple. Increase in the number of pilgrims will put the police personnel and the officials of the health department in great strain and difficulty in controlling the pilgrims of the magnitude, the plea filed in the top court says. The SLP also makes a mention about the new strain of coronavirus detected in the United Kingdom, which has led the Union government to cancel the flights from UK. It is also stated that during the pendency of the petition in the High Court, the high-level committee had raised the number from 1,000 to 2,000 per day on weekdays and 3,000 on weekends. While ordering the increase of daily pilgrims, the High Court noted the revised health advisory for Sabrimala package submitted by the Health Department on 14 December. Bureau Report.
Allahabad High Court has denied bail to Managing Director of Amrapali Group. The High Court relied on the order passed by the Supreme Court in July 2019, in which involvement of the accused in the offence had been meticulously flagged.
The Allahabad High Court has denied bail to Anil Kumar Sharma, the Managing Director of the Amrapali Group of Companies, in the case filed against him for offences committed under Section 3 and 4 of the Prevention of Money Laundering Act 2002. Justice Dinesh Kumar Singh deemed it to not be appropriate to enlarge Kumar on bail, in view of the Supreme Court's order of July 2019, in which his alleged involvement in the offence had been meticulously flagged. His conduct before the Supreme Court and the fact that the investigation was still on and money trail yet to be completely unearthed. The matter came up before the High Court after Kumar's bail application before the Special Judge Sessions Court PMLA, Lucknow, was rejected in July this year. Tracing the timeline of the scam that defrauded home buyers, the High Court recounted that the Supreme Court had relied on the findings recorded by forensic auditors to conclude that there was a prima facie violation of FEMA and other fraudulent activities of money laundering. Thus, the top court had directed the Enforcement Directorate to probe the case and fix liability on persons responsible for the scam. The High Court also observed Kumar has been accused of serious economic offences. But for the Supreme Court's intervention, the High Court noted that thousands of flat buyers would have been left high and dry by the promoters of the Amrapali Group of Companies, and that the Amrapali scam would not have been unearthed. Kumar was described as the kingpin of the fraud, cheating, diversion of funds and money laundering allegedly involved in the case. Thus, in view of the order passed by Special Judge, the nature of accusation, the gravity of offence and the punishment provided for the offence, the fact that the investigation had been going on qua other accused, and given that the scam allegedly involves a huge amount of rupees 6,000 crores, the bail application was rejected. Bureau Report.
That's all for Courts this week. From 1st of January, Court Bulletin will be presented in Hindi in new style and format. Keep watching APN.
India Legal presents Court This Week.